One of the biggest mistakes foreign companies make in Vietnam is waiting too long before taking legal action in debt cases. It often begins with good faith. You trust the buyer, you assume they're simply slow. You want to preserve the relationship, so you send polite reminders. Then another, then you wait, months pass, and then, it's too late. The debtor has vanished, restructured, or emptied their accounts. In debt recovery, delay is not diplomacy, it's danger. While you're waiting, the debtor isn't idle. They're shifting assets, changing ownership, restructuring liabilities. Sometimes, they even set up new companies under a different name. By the time legal action is initiated, there's nothing left to enforce. Vietnamese law allows debtors to legally change company status, hide assets, or sell inventory unless restrained by timely legal filings. If you haven't filed anything formal, you're not protected. In Vietnam, silence from a foreign creditor is interpreted not as patience, but as uncertainty. Debtors assume you won't sue, that you're too far away, too unfamiliar with the local system, or too cautious about legal confrontation. They exploit that window. And unless you counter with legal action, you lose leverage, permanently. When you act early, you retain control. You can choose the method: negotiation, formal demand, litigation, or arbitration. You can explore payment options, asset tracing, and collateral agreements. But most importantly, you're not reacting. You're leading, and that alone changes the outcome. Early legal action doesn't always mean going to court. It means making your legal position known, clearly and promptly. A professionally drafted bilingual demand letter is not just a formality. In Vietnam, it's a recognized legal document that proves breach, documents your response, and establishes legal standing. When LTS law issues a demand letter, it signals immediate escalation if ignored. Many of our successful recoveries begin not with lawsuits, but with demand letters that stop delays and start results. Without it, you're just another email in the debtor's inbox. A Singaporean supplier waited 6 months for payment from a Vietnamese distributor. Internal reminders went unanswered. When they finally contacted legal counsel, the distributor had sold its inventory, transferred its premises, and was no longer traceable at the registered address. LTS law filed emergency notices, but the recovery window had closed. Only partial payment was achieved. Lesson: the time to act is before silence becomes disappearance. In contrast, a Korean manufacturing firm contacted us just 10 days after the payment deadline passed. We issued a demand letter, filed pre-litigation notice, and simultaneously contacted the debtor's bank to confirm asset presence. Within 3 weeks, a settlement was negotiated, with security in the form of post-dated checks and pledged inventory. Full repayment was made in under 2 months. Same market, different strategy, very different result. At LTS Law, we work with international clients to build action timelines that protect their financial position. From the moment a payment is late, we guide clients through a response structure. Day 1 to 15, reminders and document consolidation. Day 16 to 30, legal review and demand drafting. Day 31 plus, legal action planning, negotiation or filing. This model allows flexibility without losing leverage. It's not about being aggressive, it's about being ready. Every day you delay legal action is a day the debtor gains ground. And once assets are gone or the business is closed, recovery becomes almost impossible. If you're facing non-payment in Vietnam, don't wait. Contact LTS Law. We help global companies act early, act smart, and act legally. Visit lts.com.vn to build your action plan today. Because in debt recovery, timing isn't everything, it's the only thing.